Welcome to the April 15th, 2026 meeting of the Clark County Charter Review Commission. Commissioners, would you please join me in rising for the Pledge of Allegiance?
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Michelle, welcome back. Would you please call the roll?
I sure will. Thank you. Commissioner Ottaguame.
Present.
Commissioner Donnelly.
Present.
Commissioner LeBrant.
Here.
Commissioner Erickson.
Here.
Commissioner Garber.
Here.
Commissioner Hamlick.
Here.
Commissioner Chrisley.
Present.
Commissioner Landisberg.
Here.
Commissioner Jay.
Here.
Commissioner Klein.
Here.
Commissioner Gasquet.
Here.
Commissioner Holmgren.
Here.
Commissioner Benton.
Here.
Commissioner Haas.
Here.
Commissioner Silliman. We are all here.
I didn't get to say anything.
Thank you. We do have a quorum. We'll next seek to approve our agenda. Commissioners, we have one revision, item 7. Comments by County Treasurer Alicia Topper will need to be deleted. Treasurer Topper informed us today that she's not feeling well and has been rescheduled for a future meeting. Is there a motion to approve the amended agenda?
So moved, Ottaguame.
Second, Chrisley.
It's been moved and seconded to adopt the amended agenda. Are there any opposition? Okay, seeing none, the amended agenda is approved. We'll next move to open public comment.
Thank you. We don't have anybody in the room, but we do have one online.
Okay, I will preface it with this comment. Clark County Charter Review Commission welcomes and encourages public comment. Public comment provides an opportunity for members of the community to share input with the Charter Review Commission. Comment should focus on issues relevant to the commission's responsibilities. Each speaker will have up to 3 minutes. The microphone will be automatically turned off. Once the time limit is reached, the commission will listen to comments but will not engage in discussion during public comment period. During public comment, speakers are asked to keep remarks respectful, focused on commission business. Remarks concerning private activities or beliefs of others, individual county employees or elected officials, or matters unrelated to the work of the commission fall outside the purpose of public comment. Disruptive, uncivil, and defamatory conduct is not permitted. Thank you for taking the time to participate in this process.
Thank you. Caller, you've been sent a request to unmute. Please go ahead and do so. State your name for the record and go ahead with your comment.
Hello, my name is Bradley Branham. I hope everyone is well. I'm commenting as to 2631 from last week. I read the Karatkin and Parouche paper, Optimum Committee Size versus Quality Dilemma. It was footnoted in the presentation from 2631. I must admit that the probability theory proofs were a refreshing reminder of my youth. I feel that the analysis is relevant and provides implicit advice for the construction of this proposed amendment. Using a binomial probability model, Karatkin and Parouche challenged Curtis's decision quality assertion. And the quote, the larger the team of decision makers using the simple majority, the more likely they are to reach the correct decision. The binomial model that they construct has size of committee and individual competence as parameters, where the individual competence is the unique probability of each member of finding a guilty person guilty, getting it right. Decision quality is the aggregate competence of the committee, and the committee makes in other words, the committee makes the right decision. Individual competence can be looked at like as a probability that they'll make the right decision. Like a competence of 55% is over flipping a coin, which would be like somebody in a college ethics class read Aristotle's Nicomachean Ethics, right? Well, committee size to get 90% quality would take 201 people. For instance, you go to an 85% would be just like a law enforcement officer and possibly a lawyer together, because they have the way of putting the facts together with legal structures. That would be a competence level of like 85%, and that would be the 7 that was mentioned in the proposed amendment. Now, if you go to 5, which I would say would be a judge and maybe detectives with 10 years or more experience, where they're experts at matching the facts to the legal structures, then the 5 would give you a 92% decision quality. So under the model specified in the footnote of the proposed amendment, a committee of 5 would require 95% individual's competence. A committee of 7 would be 85% individual competence. In conclusion, specification of a committee size requires the hiring body to have a method for the assessment of individual competence in applying the ethical rules. I feel this needs to be studied in the study committee and also included in the proposed amendment. Thank you very much. You guys are doing a great job.
Thank you very much.
That concludes public comment.
We'll move on to seek approval of our April 8th, 2026 minutes. Commissioners, are there any proposed revisions to those minutes? Okay, seeing none, is there a motion to approve the minutes in their current form?
So moved, Benton.
Klein, second.
It's been moved and seconded to approve the April 8th minutes in their current form. Are there any opposed? Okay, seeing none, they are approved. Next, move on to executive committee reports. Start with Commissioner Garber, please.
Thank you, Chair. Okay, I just have a couple things. I want to make sure that, first of all, I want to ask if you have any organizations or groups that you would like to have on the email distribution list. The Public Outreach Committee is working to gather these up. So please email your email addresses to Commissioner Holmgren, please. And the other item is that when you turn in your detailed policy form to the executive committee and to Katie, also make sure you're sending a copy to Michelle so she can place it on the website. That's all I got.
Thank you. And Commissioner Garber, can I ask you to make one clarification? If the committee is electing to send it to financial services, it would be copied to Mitchell Kelly at the same time, correct?
Yeah, that is correct. Sorry about that. Yes.
Thank you. Next, we'll ask Vice Chair Haas for an update.
So we put up together a request for the Scribner. That request has been finished, reviewed by legal, updated. We put in a dollar amount for this project of $10,000. And the way the request reads is anything up to $10,000, but we can approve more later as a commission if we feel the need to. That's in the hands of purchasing. I checked in with them today. They're just finishing up, figuring out the best way to get it out, and will keep me apprised, and I will keep the commission apprised. That's all I have.
Thank you, Vice Chair Haas. On that note, I just wanted to commend this body for its work in developing a work plan that allows us to go through our deliberation process while preserving our budget for services like this and for public outreach. I have one update. There are 3 amendments that have been deferred by their sponsor. One we briefly referenced last week, but I'm not sure that we did it as clearly as we should have. And I want to take this opportunity to make sure it's clear. Amendment 2628, role of council members on boards and commissions and methods of appointment and replacement, with Commissioner Donnelly as the sponsor. That was briefly referenced as being deferred, but I want to be more explicit that it has been voluntarily deferred. Commissioner Donnelly, is that correct?
Yes, it is.
Thank you. We've also received 2 other deferrals. Amendment 2638, prohibit light rail in Clark County, and 2639, prohibit tolling in Clark County, both of which Commissioner Benton is the sponsor. He has asked to defer that to next year. Commissioner Benton, can you confirm that?
That is correct.
Okay, thank you. That concludes executive committee reports. We'll next move on to the work plan subcommittee report. I'll preface it by reminding this body that in our last meeting, as we were going through some initial feedback that we received from the prosecuting attorney's office as detailed policy reports were being turned in, it brought to light that we needed to do some fine tuning of our process. And in response to that, the work plan subcommittee convened. It met on Monday and had a very healthy debate with good outcome. I want to thank Katie for being at that. She played an integral role in helping to move that process along. And as a result, there were a few changes that were made to both the study committee protocol, the work plan itself, and the detailed policy form, as well as the creation of an additional form. And the body agreed that Commissioner Silliman would present the outcome of that meeting to this group. Commissioner Silliman, are you ready to present?
Yes, sir. Thank you for the introduction to the material and the subject and what triggered the conversation. Does that sound okay to everybody? It rings in my ear just a little bit, so it sounds a little different. But because of that issue that we had with the form that we were submitting to the prosecuting attorney and the feedback we got back was a little bit different than what we expected, it resulted in a discussion and a modification to that form, which is the proposed amendment detailed policy form that everybody has. All the proposed changes in items that you would want to submit as a committee to the prosecuting attorney are highlighted in red, and those that include identifying applicable RCW, state laws, county codes, or other charter language that you're modeling after or have copied, list of impacted departments, boards, and commissions, and specifically has the County Financial Services Office been asked for a review of this proposal and maybe a financial impact statement. So some of these might not appear to be related directly to asking the prosecuting attorney, is your proposal legal or not? One more detail is a complete charter and section affected and complete proposed amendment language. So it's kind of hard for Katie to evaluate a proposal if she doesn't have language to start with. So one of the things that we discussed was, yes, it's going to be on the burden on the committees and the sponsor to come up with at least some proposed language to start with, to start a legal analysis or preliminary review. So we want to make that expectation clear. And if we give more background information and our references, then that gives the prosecuting attorney more perspective on where we're coming from and the resources that we have already checked off. Brings to mind some of the things I deal with professionally is engineer hands me off a print, says, hey, go do this. But sometimes they write that thinking from their perspective and not thinking of, well, I'm only looking at this for the first time and what information do I need? So think of Katie as this is the first time she's going to hear it, the first time she's going to look at your proposal. So the more information and resources and references you provide for her, the easier it will be for her to come up with a preliminary legal opinion about that and provide feedback. The other thing to consider is that this is going to be a public document. So including as much information in this document as possible might help later when people are evaluating, the public or other people are evaluating whether your proposal is sound or not. So the additional form detail is also to assist you, and it becomes part of the public record. The prosecuting attorney needs as much information as possible to form her preliminary legal opinion. Some of it she can't start without, like proposed actual charter language. And one of the things that we discussed also that we need to make clear is this prosecuting attorney opinion from this form is preliminary only, and it's not to be shared with the public. So the email response you get back is what we discussed before was privileged legal information that's not to be public. It won't be made public in the future either. And that's kind of a change in our understanding from before. We thought, well, that will be answered, made public. What were those concerns? But that's not correct, and that will remain private, privileged information. Only that this form will be made public. Does that make, hopefully that makes sense. With another thing that came up was a modification to the end of the work plan and what is the committee going to produce when they come back to present to the full Charter Review Commission. And so they came up with another form, and they're calling it the resolution packet. Kind of has some outline. It's similar to this, but it's going to be more succinct, probably brief. But it also includes the idea of you're going to have a concise explanatory statement for your resolution and the exact proposed language that you are proposing. So that was kind of a standard form to help us communicate to the committees, what is your objective as far as what information do you need to achieve to bring it back to the committee. Also, standard resolution language will be provided to each study committee. So we had examples emailed out by Kathy about what does a standard resolution form look like for each committee. And I believe she also emailed these two past examples, and there's more examples on the Clark County Elections website, past charter resolutions that we can look up if you need examples. But yes, the committees will be the ones that come up with the whereas statements. Those are basically the because statements, because this. These are your proposed changes exactly. Sorry, Kathy, you want to elaborate on that better?
I think I just sent it to the work plan subcommittee, those
Okay.
list of resolutions, but I will send them to everyone else tomorrow.
Okay. Thank you for making that clear. Everybody's like, what form are you talking about? Another thing that will help with the understanding of the process too is we have this form from the prosecuting attorney. She was going to present, but we have the PowerPoint. It's loaded with the information and the references, gives you an idea what the downstream process looks like, and makes it clear that at the end, we as a committee need to provide the explanatory statements, the actual language, and the steps after we approve it as a committee to go to drafting. Let me get to my list here and say, okay, so once we follow these steps to present it to this board again as a committee, if it gets approved to go to drafting, at that point, it should be like 99%, and the drafting committee will only be tweaking the language and absolutely not changing the intent. And that's why it's important to have clear proposed language and an explanatory statement. They are also going to loop in the sponsor to make sure that I think they get buy-in as well. But at that point, when we have the drafting committee and maybe before or after the scrivener actually looks at it and reviews it, it will be going to the prosecuting attorney for final approval of the form before it comes back to us as a committee for final approval of the resolution to put it on the charter. So we walked through that process a little bit, and because of that, we modified a couple of our existing documents. One is the one that about the charter committee study committee protocols. We added language in there that says, have the input of the County Financial Services Office been solicited? Has the input of the County Financial Services Office been solicited and considered? And also under legal opinion and procedures, the study committee and executive committee members will receive a preliminary opinion. That's what we're calling the response to our proposal detail policy form that you received back from the prosecuting attorney's office. The prosecuting attorney's office opinion should remain protected. To maintain attorney-client privilege, the prosecuting attorney's office email cannot be shared outside of the study committee or executive committee. by seeking to schedule a final presentation to the commission for a vote to advance an amendment to the drafting committee. The study committee represents and affirms that they have addressed, to the best of their collective ability, concerns raised by the prosecuting attorney. So that's just a clarification about the legal process. And again, that opinion provided to you by the prosecuting attorney stays private. That's attorney-client privileged information. And then the other thing we changed was the charter work plan has some additional details in it describing the committee study process and the ballot drafting and ballot referral. It says the amendment proposal study committee protocol document is incorporated into the work plan. The committees shall complete the resolution packet and include it in the committee's final presentation. That's the new form included. If the amendment is approved, this packet will be used by the drafting committee as the initial basis for development of a resolution and charter language. And then in the next part about the drafting committee, it says the committee chair shall be allowed to review. The committee chair shall be allowed a review of the drafted language prior to the final vote to refer the amendment to the auditor's office. So that's where the drafting committee is going to make sure or just check in with the committee chair that sponsored the amendment. The resolution packet produced by the study committee shall be referred to the drafting committee, which will utilize it as the initial basis of its final work. The drafting committee will be responsible for all the formatting required to prepare documents for submission to the auditor's office. But again, that's just, if the committees are doing 99% of the work, they'll just be double checking it, making sure the language is consistent throughout all our charters and won't be making a lot of changes to it. So what we're looking for today is from the Charter Review Committee. If there's any questions, we'll answer that. But also we want you to approve the new form and the modifications that we've made to the process. So at the end of the discussion, we'll be asking you to approve those.
Thank you, Commissioner Silliman. We'll entertain questions and comments. We'll go to Katie first and members of the commission. I'll add one brief overview. Commissioner Silliman's given us a lot of detail. I would add just an overall summary that the subcommittee met in response to some initial feedback that came back from the prosecuting attorney's office regarding how some of the initial detailed policy forms were filled out. That brought to light the need to revise the form. In the course of discussing those revisions, it became apparent that we needed to reflect those revisions in the committee protocol. That then made its way into the work plan. It also brought to light that we needed another form, which is what Commissioner Silliman identified as the resolution packet, which is the final work product of the study committee. And it is what would be presented back to this body in the committee's presentation. And it would be the deliverable from the study committee to the drafting committee to communicate the drafting committee's, or rather the study committee's intent and provide an initial starting point for the work of the drafting committee. So with that, Katie will let you offer comments and then we'll entertain questions from the commissioners.
So I just wanted to clarify that the explanatory statement is prepared by the prosecuting attorney's office. So that's by law. So there's the resolution language, the whereas statements, were referred to as recitals, and then the proposed charter language changes. But the explanatory statement is that little gray box that's on the actual page of the in the voter's pamphlet that is the neutral, factual understanding of what is being proposed. So that's why the PA's office prepares that. And so that would be Amber when she signs off on it. So just wanted to explain that a little bit more in detail. Everything I think is just semantics.
I was confused with that because there's the ballot title and then there's an explanation next to that. And then there's for and against statements. We didn't touch on that much, but that's also included in Katie's packet about the downstream work. So when you're working as a committee, if you're probably going to assign 3 people off your committee to come up with a for statement. And the election. I don't know if there's going to be strong enough opposition here to form an against committee. If there's not, then I think the elections department solicits from the public for an against position.
Yeah, you guys still have a little ways to go on that, so we won't get into all of that tonight, but everything in the PowerPoint that I sent, it's cited to where I found the information within the elections office guidelines, so that you guys can go and read it for yourselves. Sometimes that's the best way I learn as well.
Thank you. Yeah, we haven't yet dealt with for and against. We will do that at a later meeting. Commissioner Lanesberg, and we'll go to Commissioner Adegami.
Okay, first of all, I wasn't clear from looking at your dates, when it goes to the drafting committee and when the drafting committee has to be done with its work. And I wondered why the drafting committee couldn't actually see the prosecuting attorney's opinion to be a double check on making sure the language that we draft is consistent with what they said.
So I'll speak to the date. So we've already agreed that amendments are being delivered to the drafting committee on a rolling basis. That's why we stood up the drafting committee last week, so that as the work plan, or as the study committees rather, are doing their work and completing their work and then handing off their amendments to the drafting committee, that's on a rolling basis. We work backwards as to what is the final date by which the drafting committee needs to have their work done, so that we can take our vote with enough notice in order to get it to the auditor's office. So those dates are, the end date is fixed based on our schedule, and then the beginning date is a rolling basis. So as committees finish their work, the drafting committee will be receiving those on a rolling basis.
So what was the end date for the drafting committee?
June 19th.
And I can answer as far as the attorney-client privilege.
Yes, please do.
Okay, thank you. So I represent all of you, and so it is fine to, for my opinions to be shared within the group privately as clients. However, if we publish them during a public meeting or within the public materials that get posted on the website, we have just waived my attorney-client privilege and work product. And for an example, to explain why this is important is so the proposed amendments, it gets voted on, it gets put on the ballot, the voters approve it, and then there's a lawsuit. A group, a citizen decides to sue the county over the change. And if we waived my attorney work product or client privilege, that means that during the discovery process of a lawsuit, a future lawsuit, the petitioners could then reach down and basically claim waiver and then pull all of any related attorney work product or client privilege related to it. We can't protect it. We wouldn't be able to protect it. It would be, we would have to send it to the claimant. So that is why, again, out of an abundance of caution, I am recommending that my attorney-client privilege and work product be protected and that we don't waive or disclose it.
Thank you. Commissioner Adegami, please.
Thank you, Chair. First, I want to express my gratitude for the Work Plan Subcommittee and their efforts. This is detailed, and I think it helps us get closer to having a usable, workable, and finished work plan, which we have struggled with over the course of many meetings. Two questions. One, are we expecting to rewrite prior submittals? Will that advisory come from the chair, from the prosecuting attorney's office? How will we know that prior submitted documents need to be rewritten in this new format? Obviously, there's an additional form to complete, but just want to get some clarity there. And then I know that Michelle had sent out some resolutions to us during our last meeting. Are those the same ones that Commissioner Garber intends to send out, or different ones, or what's going on there? So just two questions.
So I'll deal with your first question, and Commissioner Garber can address your second question. We haven't yet dealt with that topic yet in this discussion yet. So in discussing with Katie during the subcommittee meeting, it was determined that there's a couple categories. So there are a few of the detailed policy forms that have already been submitted on the older version of the form. And given the nature of the amendment, that the old form was sufficient to allow Katie to do her work. And the information that was on that version of the form was complete enough, again, to allow Katie to do her work. So in those cases, no further work is needed to fill out that form. Amendment 2601 was an example. Of the others that had been submitted on the old form, they'll need to be resubmitted on the new form. And we're going to talk about the time frame for that. And then there are some that have not yet been submitted, yet they've already had their second reading presentation. Those will need to be submitted on the new form that we're discussing today. And then any amendments that receive their second reading today would be submitted, that form, the more recent version of the form would be completed. As far as schedule, we had earlier talked about a 2-week schedule from second reading to when that form would be submitted. Last week, we agreed that there would be a 1-week delay to allow for this to be sorted out. The subcommittee agreed that any second reading that has already occurred, and yet the form, if the form has not yet been completed, or if it has been completed, it needs to be resubmitted, that will be, the new deadline will be 1 week from today. Any second readings that happen today that advance to committee, the original 2-week schedule will still be in place.
Just to follow up on that, Chair, I believe last session, we, through this body, chose to approve a suspension of the deadline. So would we need to then vote on having the deadline be reimposed, or?
We're going to be taking a vote on the work of the subcommittee, all of the changes that we're talking about, and that would include the schedule that I just mentioned.
Thank you.
Commissioner Garber, can you address the other question, please?
Sure. So tomorrow I will be sending out you 3 resolutions, and I'm sending out ones that were created by the Charter Review Commission before, and I thought those might be kind of better material for you to look at to start writing your resolution. One of them will be a Word document, so you can actually take that document and edit it, and it can kind of help you in the process. The other ones are PDFs, and I will get those out tomorrow.
Thank you.
Commissioner Klein.
Thank you, Chair. This is excellent work, and I really appreciate the Work Plan Committee's work to create an impressive template. The work plan is more clear, and I appreciate it. Is there a location in perhaps in step 6, where the Scribner would be pulled in? I don't see it, and I've just scanned it. I haven't read it for detail. But is a Scribner written into the steps?
4th step,
4th step?
right above the red.
1, 2, 3, 4.
Sure. In step 6, it does say retainment of Scrivener
Scrivener. Got
services
it.
to
Very
format.
good.
Yeah.
On that, I would move to accept the work plan, the forms, and everything as presented.
Second.
Thank you. I think we had some other questions first. Would you be willing to suspend your motion until we let others speak?
Yes, sir.
Okay, thank you. Commissioner LeBrandt, please.
Yeah, I had some questions on the attorney-client privilege component of it. My concern being that it doesn't allow this body, before voting, a chance to evaluate whether any potential concerns have been addressed sufficiently. So thinking through, if we open that box that allows a potential contemplated plaintiff to reach through discovery on your feedback on these, if I'm understanding that correctly. Okay. I'm wondering if there's any other downside to that. Like if we open that box, we make it available for the rest of the commission who's going to be voting on whether or not we individually think those concerns have been addressed, then that also is an open box later on down the road.
Katie, would you be able to address that, please?
Yes, so we contemplate this on Monday. And one process that, and I'll kind of describe how we generally do it for the county, is that let's take a public works project. Public Works starts developing the project, similar to a work plan or a study group. They consult with any other impacted departments. They put that together into the project proposal, or let's say a contract. And then it goes through budget review. So you see we're kind of checking off all the same boxes. And then it comes to me to kind of evaluate the entire thing. And again, I will provide that feedback in email form, but of course my emails do not get put into the packet that then is sent to Kathleen or to council for the hearing or the consent agenda. And so the project manager then prepares what we call a staff report, and they have to sign it, essentially guaranteeing that they have followed these steps. And then also, so if it's your amendment, you would sign basically what we're calling the resolution packet, correct? And you are then establishing that you have completed these steps, legal being one of them. And then also my recommendation was for Brandon to also sign the form, because the executive board is also a part of all of these emails. And so him signing that form would also be that assurance that procedure was followed correctly and in a timely way. And then again, with the staff report example, then that packet of information, I don't sign the staff reports, but I review them to make sure, in fact, everything was followed. And then it goes to either Kathleen or the council open public meeting, and so then that's the way we do it within the county, just very generally on how we do that without putting in the packet my emails. Does that answer your question?
Getting there. So following that same example then, before something gets to the council as a vote, members of the council would have opportunity to review that, is my understanding, before they vote.
If they wanted them, yes. But generally, because we do this multiple times a day, every day, it is the signatures on that staff report are the assurance to council that all the boxes have been checked and that process has been followed, and that what they are looking at is legal, constitutional, it conforms. And so that's because also, some of these packets that go to Kathleen or council are 57-page contracts, or they're 200-page proposals. And so this is our efficient way of also getting through that process as it goes up the ladder. But the signatures on that page are the responsibility that all of those processes have been followed and that they conform to law.
Okay. Can a member of this commission who's not on the executive committee or the study committee have the opportunity to receive or review that correspondence?
Yeah, I have no problem sharing it with anyone on the commission. Not at all. The way we're doing it now is that it's the e-board and then the person submitting the proposal. Because questions go back and forth, there's also dialogue. So we want to make sure we're not having chain emails, or reply alls as, or serial meetings with that. So so you have several members that can also see what I've written back to, but I'm happy to share that with anyone that wants to see it. And please, you guys know that I speak up when I see something. So if I also see that something is not conforming or that my legal advice is not being followed, as demonstrated already, I will speak up and say, I strongly encourage you to follow da 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 da, and whatever that may be. So please rest assured that my job is to keep you guys on track and that I will state. Plus, there's another check that again, I have to still sign off one more time, and then Amber still has to actually sign the resolution. And so there's several more legal checks that go into this, that if it does not conform, it will not get signed, or we will not keep moving it through the process. So I hope that assures this group.
I want to make one clarification. So first of all, Commissioner LeBrant, does that answer your question, or are you satisfied with the documents in their current form? Or are you looking for some modification to these documents in order to satisfy your concern?
My preference personally would be if we can be looped in as a commission on that feedback from the prosecuting attorney's office, since we're going to be asked to vote on them. I mean, you seem like a trustworthy fellow. We've got lots of good trustworthy folks on these study committees, but we're going to be asked to vote individually on this. And I think we can still, especially when we've got the disclaimers at the top of the emails that are, attorney-client privileged, that kind of thing. We can, I think, still maintain that within this body.
So would the current, or I should say the updated version of the study committee protocol, which is up on the screen right now, in red, on the second line of red, where it says the prosecutor's office email cannot be shared outside the study committee or executive committee, would you want that to say it should not be shared outside of the Charter Review Commission?
That would be my preference. Yeah.
Okay. And Katie, would that be acceptable to you?
That's fine. You guys cannot reply all.
Okay. All right. So when we get to the point of seeking a motion to approve these documents, then we'll make sure to capture that.
Thank you.
I'm sorry, I'll come back to you in just a second, Commissioner Landsberg. Katie, I just want to ask one clarification. The members of the executive team don't recall in our study committee meeting a discussion about any of us signing something. So could you clarify what you were saying about that?
I'm sorry, I was packing up and I was like, I gotta go. Just remember the department head signed the form too. And so I did say it as I was trailing out of the meeting. So I apologize for that, but it's common practice. For example, again, Public Works can later signs all the staff reports as well before they come up. So those are our internal checks in the process.
Okay, thank you. I'm not opposed to it. Just want to make sure we understood what you were talking about. Commissioner Landsberg, thank you for your patience.
Okay, so we talked about, and this addresses what you were talking about, Commissioner LeBrant, that the drafting committee would get the prosecuting attorney's input. So when we're reviewing the language, we're also a double check before it comes finally up for a vote. And so you did say the drafting committee could get it when we're doing it. So the question, I guess, on this process is, as we're voting on it, when will each member of are we going to limit the time frame when the whole commission gets it? Or are we going to how are we going to disseminate it? Because the drafting committee needs it before it's voted on. You want to see it before you actually vote.
I think the, I think the milestone that Commissioner LeBrandt was speaking to was the vote at the end of the study committee's work before it's sent to drafting. Drafting committee will be doing no policy evolution. And so the development of the amendment policy and the extent to which it does or does not satisfy any concerns from the PA's office happens within the committee. Not the, I should say the study committee, not the drafting committee. The drafting committee is policy neutral and not changing anything. So the real significance and timing of hearing from Katie would happen prior to this body hearing from the study committee and taking a vote as to whether or not it would advance to the drafting committee. Once it's to the drafting committee, then policy evolution is done and the drafting committee isn't necessarily changing what they do based on what they hear or don't hear from Katie's office. That decision will have already been addressed and dealt with in the vote between leaving study committee and before going to drafting.
So where in this process is the lawyers that we've paid to review the language?
In the drafting committee, not the Scrivener services, in the drafting committee.
So we will draft what we think is appropriate based on what's submitted to us.
That's a good question. So this is why we have this resolution packet. So during the course of our discussions, we recognized that there was another document required for the study committee to produce their final work product, which are the items that are requested: a final narrative describing the amendment, the resolution, and the text of the charter language. That then is what is delivered to the drafting committee as its initial draft and beginning of its work. So the drafting committee has a starting point, and it is the starting point as defined by the amendment study committee based on this resolution packet. The identification of the need for this resolution packet came out of the work plan subcommittee meeting on Monday.
So one more question on the timing of how we're voting on the final review of the process is, are you going to say by the Monday before the meeting, when we get the final, whatever we're going to be voting on, we're also going to have in that packet the Katie's, the prosecuting attorney's comments? When, I mean, it helps us to review it if we have it at that.
Well, I'm going to go back and mention what I said a little while ago. That what we just were discussing is that Katie's opinion would be shared with all members of the commission, and it would be shared before we take the vote on whether or not to advance an amendment out of committee into drafting.
Okay, but I'm looking at when I'm sitting here as a commissioner, how many days before we're doing the vote can we expect to see what you've written and what we're voting on? Because lots of times everything comes up and we're coming in today and we're seeing it in the binder.
Well, you're free to print it out yourself, but it can't be in the materials that are posted, you know, in the agenda publicly.
And it can't be quoted.
And yes, and because you can verbally waive my opinion as well.
I'm just trying to figure out time frame when I'm doing my work.
Well, we could agree that, Katie, when you issue your opinion, could it go to the whole commission at once?
Yeah, I can send it to everyone.
Okay.
And the ones that, you know, I think there were 4 that came in last week and we kind of called them the guinea pigs, because that's where we sort of learned what was working, what not. And it also provided a spectrum of differences. And so I'm comfortable if we send those to the whole group as well, so that everybody can see those as the preliminary review. And then we'll start this process with my replies will go to everyone from here on out. And that's fine with me.
Okay, thank you. So to speak a little bit to more specificity on the schedule. So keep in mind that what triggers Katie's opinion is the submission of the detailed policy form. We were just discussing the time frame by which that is due. It's either going to be due perhaps 1 week from today for many of the committees, or 2 weeks from today for those who are be presenting. Katie then needs to have some time to review it and form her opinion. That then would be sent out. The members of the committee would receive that, and they need time to address it and perhaps evolve the amendment before they're ready to go back to this body for final presentation, perhaps hoping to seek it to or send it to drafting. So I believe that there will be a natural timeline for everyone to see the opinion, contemplate it, and hear it before we're asked to make a vote on something. Commissioner Sillen.
Just want to share something that brought me a little bit of comfort in this process when we discussed it in the work plan committee is when we submit this form to Katie, it's for a preliminary opinion, and that's how we chose to define it. So it's not the final opinion. And when we discussed it, the original plan was for the committee to come back and explain to all of us in the meeting how we addressed the legal concerns, but that would reveal privileged information. So, but what helped me is understanding if that's not the final legal review. So if a sponsor or committee decides to take a shortcut and not fully address the legal issues, once we approve it as a commission, it goes to drafting, they draft it up, it goes to her for her final approval. And if she doesn't approve it, it's not coming back to us as a resolution to approve until she's satisfied. So she has the original concerns she had with the amendment that she sent to the committee. Then she's going to get it back in a final drafted form. She's going to review it again with her original concerns. If they're not checked off, she's not going to approve it. So that's the final check on somebody trying to wiggle something through without addressing it. And so when the way we wrote it in here is when you are presenting it, you are representing to the body here that you have addressed to the best of your ability the concerns that were shared with you by the prosecuting attorney.
Thank you, Commissioner Simone. Commissioner Gasday, please.
So I'm just kind of concerned with all the scope creep on the subcommittees, considering some of them are expected to start presenting within the next 2 weeks. And I mean, if Katie's going to get, 40 proposals next week, she's not going to be able to get that feedback back to the committees, who are then expected to present and have their whole packet ready. And I don't understand why the resolution needs to be written by the committee, because that's what the drafting committee is supposed to do. They're supposed to draft the resolution, and there's nothing in the resolution that cannot be derived from the proposal detailed policy form. We're already giving purpose and policy intent, detailed description, and the ballot language. So there's no space in here, given our schedule, for the committees up front to actually receive that feedback and do anything with it. And also, so our actual final date is July 8th. That's the day we have to vote on the resolutions. And then, so there's a huge gap in between the last proposal and when those resolutions are voted on. And there's no space in here for feedback received during our town halls in May either. So maybe there should be some procedure for committees themselves to present, get approval, but make minor changes that are approved by the body before being given to the drafted committee in the month of June.
Well, thank you for those comments. I'll share what I believe was my recollection of what was discussed in the work plan subcommittee, as well as my own personal opinion. The development of the resolution and the charter language itself is the primary work product of the study committee. And the identification of that language is best developed by the study committee and not delegated to the drafting committee. And I personally believe that's appropriate. I believe that's what the study committee agreed upon as well. And that it doesn't necessarily take meaningful work away from the drafting committee. They have an important role to make sure there's consistency amongst the various amendments. And as far as the timeframe goes, the executive committee has given some thought to that timeline, and we are preparing to show a proposed schedule of committee presentations today with some consideration given to the simpler amendments that could go through all these steps and then put them into the schedule earlier. Commissioner Garber, for example, is prepared to do exactly as these documents suggest and be ready to present as early as next week. And there are other commissioners whose amendments are seen as being able to go through these steps and be ready to present the next week. That would then mean that, we're 3 weeks from today before more complicated amendments are asked to make a presentation. The executive committee feels like that is enough time to do this. As to the question about whether or not it's too much work for the committee and it's taking steps away from the drafting committee, I personally believe that the way it's presented is appropriate, but that would be a discussion for this body to decide. Commissioner Holmgren, please.
Yeah, I wanted to comment on the presentation schedule. It seemed like it sounded like that we were going to be approving that along with the rest of these changes. And I worry that the timeline means that we won't have, I guess we haven't talked at all about what is the timeline of receiving feedback from financial services when we submit to them, if we're going to get that kind of feedback. But then also, we're planning to do quite a bit of a push for getting public feedback. And it seems like the main policy discussion, debate, and vote will be on the presentations. And that will happen for many of these before we've received it, or we've had time to receive public feedback. And so that seems like out of order in terms of the way that normally you would collect feedback from the public.
Thank you. Those are fair comments. And public outreach is important. We want to make sure that that is due consideration is given to that. As far as the time frame of hearing information back from financial services, I have a call scheduled tomorrow with them to get more definition about their turnaround. They've been asked if they can respond back in about a week after they receive the submission of the detailed policy form. We'll find out tomorrow if they think they can accommodate that. Commissioner Garber and others have received some feedback already from them. So, oh, you haven't? I thought you said you did. Okay. So that is still, that is a topic that needs to be resolved. Hopefully we'll get some resolution tomorrow. But as far as the public outreach goes, keep in mind that we have a total of 4 votes required in our deliberation process before something actually finally goes to the ballot. And while public outreach feedback earlier is better than later, keep in mind we do have one, what we call amendment portfolio left in our work plan. And that is after something goes to the drafting committee on this rolling basis and the drafting committee completes their work, it goes into the portfolio. And we won't be taking that final vote until later in July as to what actually goes to the ballot. So we will be making votes between now and then as to what leaves study committee and goes to the drafting committee. But what actually goes to the ballot, that vote won't happen until July. So between now and July, public outreach and feedback on those amendments that are sitting in that portfolio would be very meaningful and still have influence on those final votes. Commissioner Lagwame, please.
Thank you, Chair. Given the comments I've heard from my fellow commissioners today, I think it would behoove us if I were to defer 26-35 until 2027. I'm not certain if it sounds like we got complete answers at all on what the expectation should be for the county staff to turn around the volume that we are going to put before them. And to me, it seems like maybe it's realistic, but I don't know if this timeline is going to work. So I would like to formally withdraw that proposal. Thank you.
Okay. Then for Commissioner Lagwame, Commissioner.
Apologies, I meant to say defer. Thank you.
Deferred. 2635, public defense adequacy and transparency, then is deferred to 2027. Okay, commissioners, we are coming up on the time when we normally take a break, but I feel like it would be appropriate for us to see if we can't reach some resolution on this topic before doing so. During our discussions, I think there's some consensus around at least one revision with respect to the study committee protocol, which would call for the prosecuting attorney's office to be sent to all members of the commission once it's developed. After that, the only other potential revision that I think I heard was a question around whether or not the study committee would be tasked with completing the information that is asked for on this resolution packet, which is the resolution and the resolution statements, as well as the actual charter language. If there's agreement that that is appropriate for the study committee to do and represent their final work product and deliver it to the drafting committee, then no further amendment to these documents would be required. If there's a belief that that should not be asked of the study committees, then we would need to seek some additional amendments to these documents. So is there a motion as to what this body would like to accept? And I will also add that within our motion, we can come back and talk about a schedule separately, but let's talk first about the documents.
Chair, I would like to move to strike the schedule from the documents and only consider the protocols and the forms.
Commissioner Lagwame, just to confirm, you're making that motion with the intent that schedule would be a separate motion?
Yes, Chair.
Okay. And can you clarify what you're talking about, the schedule by which the
There is a
detailed policy
presentation schedule at the end of that, and that is the one that I would like to see stricken from the main motion.
I'll second the motion. If I can clarify, we're talking about the work plan changes, the study committee protocols as amended, the amended proposal detail policy form, and the new presentation or resolution packet form.
Correct. Yes, I would like to consider all of those documents as named and remove the committee presentation schedule.
Yes.
Okay, so one clarification, the study committee presentation schedule was intended to be a separate discussion, not grouped into the acceptance of these documents. So we will come back and deal with that separately. So the schedule that was referenced earlier was the schedule by which committees will be required to submit the updated detailed policy form. So there's potentially three things that we'll be discussing, two of them right now. One is the acceptance of these documents with one revision that we've already identified. Second would be the schedule, the timeframe by which committees are required to submit the updated detailed policy form. And then later in this meeting, we are already planning to come back to talk about the committee presentation schedule.
Yes, I thank you for that clarification, Chair. I believe the study committee protocols, the resolution packet, the detailed policy form are all, in my estimation, good to adopt. And so I would move to adopt those three. I believe the work plan, the presentation schedule, and the two other schedules you mentioned there in your statement are not yet ready.
Thank you. So if I understand your motion, then it is to adopt the revised work plan, the revised detailed policy form, adopt the new resolution packet and its requirements, and also to adopt the revised amendment proposal study protocols with the revision that the prosecuting attorney's office will be simultaneously shared with all members of the commission. Is that an accurate summary of your motion, Commissioner Alagome?
Negative, Chair. I think the work plan wasn't meant to be included in there, just the protocols and the two revised forms.
Yeah. I think that's what he's saying, and that's what I clarified when I seconded. There's two protocols and two forms that we're approving.
And I'm talking about these three documents total, not the work plan.
Commissioner Alagome, are you seeking to exclude the work plan because there are dates included in it?
That is correct, Chair.
Okay. Okay, so the motion on the floor is to accept the revised version of the detailed policy form, the new resolution packet form, and the revised study committee protocols with the amendment that the PA's opinion would be sent to all members of the commission at the same time. Is there a second?
Klein.
Okay.
I second it.
Okay, so
Is there any discussion? Commissioner Landsberg, did you have any comments? Nope. Okay. Are there any opposed to this motion? Commissioner Gaskin, you're opposed? Okay. Are there any comments that you'd like to share before we then take it to a vote?
No, it's just my issue with the scope creep for the committees.
All right. So we won't adopt this by unanimous consent. Instead, we'll go to a vote. The motion on the floor is to adopt these three documents as described. Michelle, would you please call the roll?
Commissioner Ottaguame.
Aye.
Commissioner Donnelly.
Aye.
Commissioner LeBrandt.
Aye.
Commissioner Erickson.
Yes.
Commissioner Garber.
Aye.
Commissioner Hamlick.
Aye.
Commissioner Chrisley.
Yes.
Commissioner Landisberg.
aye.
Commissioner Jay.
Aye.
Commissioner Klein.
Aye.
Commissioner Gasquet. Oh, you abstain from this one?
I'm a no.
Okay, just a no. Commissioner Holmgren.
Aye.
Commissioner Benton.
Aye.
Commissioner Haas.
Aye.
And Commissioner Silliman.
Yes.
14-1.
Okay, thank you. The motion carries. Commissioners, I'd like to entertain a motion for a 5-minute break.
So moved. Commissioner Jay.
Seconded Landisberg.
Are there any opposed? Okay, we will come back at 6:15. Welcome back, commissioners. Thank you for your work in the first part of our meeting. Just before we break, we approved 3 of the 4 revised documents that the work plan subcommittee had brought forward. We still need to address the revised version of the work plan. Michelle, would you please be able to put that up on the screen?
Yes, before we move on really quick on the last motion by Commissioner Ottaguame, it was originally seconded by Commissioner Silliman, and then it was seconded again by Commissioner Klein. I need to verify for the record who actually is seconding it.
Use hers.
Thank you.
Commissioner Klein.
Okay, now what do you want to?
Okay, Michelle, could you please put up on the screen the, at the top of the document, it says charter work plan. That's it right there. Thank you. Okay, commissioners, in the course of the subcommittee, the work plan subcommittee's work, some revisions were made to this document. I believe you have it in front of you, and those revisions are shown in red text. The last motion that we approved did not include this document. And so would like to entertain any discussion around the prospect of accepting it as is or discussing what changes, if any, this body would like to suggest. Commissioner Ottaguame, please.
Thank you, Chair. I think the text of the document itself is quite strong. And again, I do thank the Work Plan Subcommittee for their work in revising it. However, I do think to some of the earlier comments that were shared by my fellow commissioners, the increase of the work that's needed for the study committees and the amount of remaining time we have based on the volume of proposals that are before the commission make these dates seem unrealistic. So I'm not certain what the right answer is, but I do feel like we need to look at taking perhaps some of the time out of drafting and the time given to the scrivener, what have you, and moving it up in the schedule to permit for the float that comes from relying upon external parties, such as the impacted departments or boards and commissions, or working with the financial folks who it sounds like haven't gotten back to anyone yet, despite date of submittal, giving the prosecuting attorney's office adequate time to go through the volume of what's going before them. So those are my thoughts on this.
Is there a motion in there or a comment?
I believe you had asked for any discussion on it, so that was meant as discussion, but
Okay.
if a motion is needed.
Okay, thank you. I just want to make sure we didn't move past the motion. Is there any other discussion on that topic? Commissioner Holmgren, please.
Sorry, Commissioner Ottaguame, can I ask for some clarification on your comment, which was, are you suggesting that we change the process so that proposals could be submitted to the drafting committee before the second reading presentation has happened?
Thank you for the question. That was not the intent of my comment. My comment was to say that if we're looking at the schedule as buckets of time, the buckets of time are allocated to the different parts of the steps listed in the work plan. Just thinking we take some of the time out of one of the buckets and add it to another to permit the study committees to have more time, to permit the prosecuting attorney's office, the financial folks to have more time to go through the volume of proposals that we have at this stage. I think when we get down to drafting, we perhaps will have fewer proposals, which might require less time, but it looks like a lot of it's allocated quite evenly between the steps remaining.
Commissioner Holmgren, did you have a follow-up comment, or are you ready? Okay? All right, thank you. Commissioner Garber, please.
Okay, thank you. Well, looking at this timeline that we have, that we spent a lot of time on, and that's written into our work plan, we have to kind of work back from like the deadline of the date that we have to give it the resolutions to the auditor, and then backwards to the PA. Moving it forward, I mean, these are reasonable dates to allow us to get all this work done. I mean, if it's maybe getting one extra week, maybe that could be built in. But beyond that, we're not going to be able to get enough proposals completed and ready to the auditor in time for the ballot. Maybe it's a concern about that list of impacted departments. I know that was a new addition that was added that kind of complicated it. Maybe, I'm not sure if that is an absolute requirement. It just says to list them, but it does not maybe something like that could be reached, but we kind of need to keep with these timeframes or we're not going to be able to get them to the ballot, my opinion.
If I may,
Commissioner Lagwame, please.
the question isn't, should we move the deadlines? The deadlines we acknowledge are what they are. The question simply is there time in one of the other buckets for one of the other steps, which can be allocated to some of the steps that are before us now, right? So just shortening the timeline for some of the steps later in the process, given that we expect the volume of proposals to decline, and adding that time here to the front of the process to give the study committees and all the other individuals time.
I believe Commissioner Silliman had his hand up, then we'll come to you, Commissioner LeBrun.
As you touched on earlier, some of these are, this is kind of a rolling date. It's not a hard date where everybody's in this bucket and then everybody's in this bucket. If you're done with your second reading, you've submitted your form and you get it back and your committee's produced it, you get to come do your committee presentation and then it goes straight to drafting committee at that point. So it's a rolling thing. So in my view, the person that is most engaged and interested in getting their amendment approved is the sponsor and the committee that joined them. So that's why I completely approve with putting the most work on them and we're simply saying, if you produce the details, it'll make it easier for the prosecuting attorney to complete their work. It'll make it easier for the drafting committee to complete their work and get yours through the process faster. So I think it's just on us as individual committee sponsors or amendment sponsors to work to get our stuff done as soon as possible. And I don't see the dates as hard. I see them more as guidelines or goals. Thank you.
Thank you. Commissioner LeBrun, please.
So thinking back to the work plan subcommittee meeting, original, I think it was our first one. One of the issues that we identified early on is that folks might not choose to defer their proposals to 2027. And that's definitely coming through to fruition. And so the workaround with that is to have this body vote on all of the second readings before we determine which ones are going to get time to commit to present for committee, present their committee presentations, ranking those based on how many votes we get out of those second readings. So that was the workaround for that. That's why that second reading phase gets so much of the time allocated to it, because we're going to end up, we're not whittling down the field of proposed amendments aggressively enough or fast enough to have adequate time for those committee presentations. So that's kind of the numeric time crunch that we're in.
I'll add one comment and then we'll come to you, Commissioner Donnelly. So I don't know yet that we are in a time crunch, that we are running out of time for committee presentations. I think it might actually be the other way around, where I think to Commissioner Adegwame's comment that are we giving committees enough time? Not are we running out of time? But to your point about the second reading votes, that's a good reminder that we have agreed that second reading votes would be used as a basis of prioritizing how we consider moving amendments forward should we find ourselves in a schedule crunch where we do need to make some decisions about a cut line, where if things are not, if we don't have organic attrition and we need to force the issue by making some limiting decisions on how many continue to move forward for schedule purposes, then the number of votes received in second reading would be used. That's still a tool that's available to us, that it is not yet apparent that we need to use it, but it's there if we need to. So I don't think I'm saying something different, just reminding how we would rely upon that. That's out there to be used if needed. The apparent need for it is not there yet. Commissioner Donnelly, please.
Yes, thank you, Chair. I'd like to just point out that I think that the process and the timeline as set forth by the subcommittee is very challenging, but it is achievable. And I think the sooner we get started on the better, and that accepting it as it is now would be appropriate. I also think it would be very helpful to be able to tell financial services and legal services the dates on which these amendments will be having their committee reports. I've already gotten a request from Mitchell Kelly. He's trying to meet deadlines, but I wasn't able to tell him exactly what the deadline was. So now that I have my estimate of, I think it's May 6th or something, I'll be able to get back to him and let him know that. And that will be very helpful.
Thank you. Commissioner Garber, please.
So looking at this schedule that we did create, and this was just kind of our idea, we still actually have 2 other dates beyond June 3rd that we could theoretically, going by the work plan, that we could have our presentations, June 10th and June 17th. And we were also talking about there could be 4 presentations per meeting rather than 3. So if we need to move them further down the schedule, we do have some other weeks that are still there. If that gives everybody time to have those impacted departments and get that financial information. We do have a couple extra weeks toward the end.
Thank you, Commissioner Garber. So that building upon your comment, the preliminary schedule that was put together for committee reports has no more than 3 committee reports in a given meeting. And that, as Commissioner Garber pointed out, based on all the amendments that are before us still, that would have committee reports concluding on June 3rd. If we were to limit committee reports to, say, 2 per meeting, then we would start to take up the June 10th and June 17th dates and would create more space and more time for the committees to do some of their work, which I think would be at least a partial treatment of your concern, Commissioner Adegami. Commissioner Holmgren, and then we'll go to Commissioner Chrisley.
I was going to save this for our discussion of the schedule, but it seems like we've kind of moved into that. My thinking is, why be so prescriptive about laying out what order these are in rather than just providing there are slots available and that the committees will let the executive committee know when they're ready and would like to schedule their presentation?
Well, that would be the ideal, but human nature being what it is, most people are going to ask to go in late May or June. And we will, in fact, find ourselves in an artificial time crunch at that point. So we do need to schedule these. We do need to have some scheduled discipline. So I personally I would not be in favor of an open slate and just come when you're ready type of approach. I think that there is some discipline needed. A schedule like this is appropriate. We can modify it, but to leave it open and just wait for people to sign up, I think will end up being problematic. That's my personal opinion. Commissioner Chrisley.
Thank you, Mr. Chair. To piggyback off what you said a little bit, I feel like, it's going to take what it takes, right? You put an amendment up, you're going through the process, you know what the dates are, you know the deadlines. If you're scheduled to be on May 6th, then you put up an amendment and you put in the work to do it. Barring there's no hang up at legal or financial, then there's no reason why you shouldn't make that date. If you didn't feel like you could get the work done, you should have kept the amendment to yourself.
I believe Commissioner Haas had his hand up, and then we'll come to you, Commissioner Landsberg.
Just one clarification to start with. We actually are scheduled now to finish up on May 27th. So we have a little more breathing room since
June 3rd.
No, he deferred that.
Oh, that's right.
So we're at May 27th now. So we have an extra week. I don't know how many of you have had a deadline come up and you've had 3 weeks to get whatever it was done. And at 11 o'clock on the deadline, you're finishing up what you could have done 2.5 weeks ago. That's where I think the deadlines are very important in this process, because if you don't have it's, as the chair said, it's human nature. If you don't have a date that you've got to be done by, those get put off, and then we're going to have a huge pile of them at the end of our timeline. So I'm in favor of the deadlines. I'm also in favor of some grace and some flexibility if needed. I would just say if it is needed for some reason to communicate with the executive committee, and we can try and work things in because life happens.
Thank you. Commissioner Landsberg, please.
I think we started off at some point in time saying some amendments are very simple and some are way more complex. And so I think that whoever has the more complex amendments might set forth to the executive board like tomorrow or whatever and saying, I believe my committee is complex and I would like my deadline to be Y instead of X. I also think, you've said those who presented on this day have this deadline and whatever. I think you should be very specific and actually identify the resolution and the date, so that we're all on the same page.
I think we are in agreement with what you're saying, that the schedule does have specific amendments identified by date. I think what's coming out of this discussion is that the schedule could be modified by calling for 2 committee reports on a given meeting. That would spread the work out a little bit more and give some of our more complex committees more time to work. Commissioner Adegwami, please.
Thank you, Chair. Move to approve the work plan as written.
Second, Benton.
Okay, so it's been moved and seconded to approve the revised work plan, which is up on the screen. Is there any further discussion? Okay, are there any opposed to approve the revised work plan? Okay, seeing none, it is approved. We'll wrap up this discussion regarding schedule. The motion that we would like to entertain is the requirement for the updated detailed policy form for any committee that has submitted their form already, but has not yet heard from Katie that it's acceptable. In other words, if you need to fill that form out again because the first attempt either didn't have the information or didn't allow Katie to do her work, then that form would be due 1 week from today. And if you are doing a second reading today and it's approved to the committee, that form would be due 2 weeks from today. And then additionally, the study committee presentation schedule would be modified to have 2 committees per meeting with an attempt to schedule the more complex amendments later in the system, later in the schedule. Is there such a motion?
Move to approve the schedule for the submittal of the revised proposal detailed policy form to be 1 week from this meeting for those that have already been submitted and 2 weeks for those that pass second reading.
I second it. Garber.
Discussion.
Discussion, please.
I have a question. If we have submitted the form and we have indeed heard back from Katie, do we still need to submit the revised form, which I have no problem doing?
If you have received a response back from Katie, then you're done.
Okay.
You would only be submitting the revised form if you've not yet submitted it, or you did submit the first one and Katie told you didn't have the information needed. Any other questions, Commissioner Holmgren?
I just want to confirm that the motion does not include the change to the schedule with the 2 meetings per.
Correct.
That is correct.
Okay, so the motion on the floor is with respect to the schedule for the requirement of the submission of the detailed policy form. Is there any more discussion? Okay, is there anyone opposed to the motion? Okay, seeing none, then is approved. The last topic then would be just to address the study committee presentation schedule.
So what we can do is we can rework it, and the chairs that think that theirs are very complicated, if you could reach out and let the executive committee know when, there are still dates on June 3rd, June 10th, and June 17th. So we could possibly move them to one of those to get it, to make sure that you're able to get that financial and that impacted. If you just reach out to us, then we could provide a new schedule.
So the executive committee can go back with this revised framework of having some additional dates to work with, 2 presentations per meeting, and come back to the next meeting with a schedule. Commissioner Garber is planning to make her presentation at the next meeting on 2601. Is that still correct?
Well, I haven't heard back from financial, but I do believe that this one has no financial impact, but that is my plan.
Okay. So we'll proceed with that. So rather than asking for a specific motion on that, what we'll do is we'll come up with a revised schedule based on these parameters that we've discussed, bring that back for discussion next week. We'll point out, Commissioner Alarguame, we did endeavor to accommodate your absence on the 20th. You'll note that the preliminary schedule did not have you scheduled on that day.
Thank you, Chair. That is appreciated. I did notice that.
Okay, well, Commissioners, thank you. I know that was a long discussion, very important. It's fundamental to our work. We'll move on now to committee reports. Start with Public Outreach Committee. Commissioner Holmgren, do you have something you can share with us?
Yeah. Just as a note, we're still waiting to hear from some of you about the town hall dates that you're available, or if you have preferred locations. If you can look back at your email, I sent one. I'm sending a follow-up email tomorrow. It's pre-scheduled, so you'll get that. We're hoping to do those in the month of May. We're trying to get feedback from the public. You will not need to do any type of endorsement of proposals or anything like that. They are strictly meant to be us seeking feedback from the public on the proposals that are on our docket. Website updates, hopefully the feedback form will be going onto the website this week. Once that is ready, I will make sure that you all have a chance to see it so that you can share it with anyone that you feel that would be appropriate. Commissioner Garber already mentioned that we're working on creating a newsletter that would be a weekly update of the activities of the commission. We're looking into how we would manage that process, some sort of newsletter management service. Other county departments use it, so we're looking into what's available. You will also, if you do have organizations or organization-related emails that you think should be receiving newsletters from us, please send them along to me. I will help manage our preliminary list. I would recommend not including individuals. I think individuals need to opt in to our newsletter rather than organizations. So if you have individuals that you think, once we have the link to the newsletter, you can send that to them so that they can choose to sign up. We're also working on a social media presence. Commissioner Gasquet is kind of taking the lead on that, and she's going to send out some notes to all of the chairs of the study committees with just a question or two about how they would like items that they're proposing to be discussed on social media, just so we get the language right. Obviously, this will need to be very short. And then finally, as part of the town halls and other public outreach, we're hoping to do some printed materials. So that would be a printed version of the feedback form. So that's asking the question, your name, where do you live, what proposals or comment do you have, detailed comment, and also a brief printout that has description of what the commission is, what it does, and a link to the online form. And in order to do this, we've reached out to the county printing office, and they've estimated that the budget for printing about 1,000 items is going to be less than $200. And so we're asking for approval to spend up to $200 on printed materials for public outreach.
Thank you. So regarding that, are you formally asking the body to approve?
Yes, we are formally asking.
Okay. Would you, so before we take that to a vote, would it be possible for the Public Outreach Committee to put together a best estimate of a budget so that it could be brought before the body for general review and discussion, understanding that you need some upfront approval to get things moving now, but maybe paint a broader picture of what you're thinking, what the expenses might be?
Yes, we can do that. We'll bring that next week.
Okay. Would you like to make your motion?
Sure. I move to approve or allow the Public Outreach Committee to spend up to $200 on printed materials.
Seconded, Commissioner Jay.
Okay. Any discussion? Commissioner Adegwame, please.
Thank you, Chair. I just wasn't sure if I caught in there what printed materials they would be.
We've discussed two items. One is they're both half-page forms, but one would be a written comment card that mimics the feedback form, and the other would be a brief description of the Charter Commission plus a link to the online feedback form.
Thank you. And hearing that, I'm inclined to support this motion.
Any other questions or comments? Mr. Jay?
Just a quick clarifying question, comment, I guess, more of a comment, just to make sure that we'll make sure that they're usable, not just for these events in May, but, can be used so we don't waste any paper or costs.
Yes, the hope is that given that we're going to be printing off so many, because that seems to be the recommendation of the printing office, I'm hoping that we can just give many of them or some of them to all of us so that we can share them with appropriate audiences.
Commissioner Garber, please.
And we also talked about providing them to to Marilee McCall when she goes to neighborhood associations. That would be a really good spot too.
Okay. Is there any opposition to approving the Public Outreach Committee to spending $200 on printing? Okay, seeing none, it's approved. Thank you for your work. Is there anything else that you'd like to share?
That's it for us.
Okay. All right. Well, in the interest of time, we'll try to move quickly through committee reports. If a study committee has a substantial update that they'd like to share, I'll give you the opportunity to share that. If it's not important that we get into the details, then I'll invite you to just say pass. Starting with 2601, clarifying nonpartisan office elections, Commissioner Garber.
That one, I have provided the resolution language and the charter language to the committee, and it will be presented next week.
Thank you. 2607, land supply and construction cost, Commissioner Jay.
I'll be resubmitting the policy detail form per the new instructions. And other than that, meeting with people from the developers and engineers advisory board to hear their input. I've read their bylaws. But aside from that, no other updates.
Thank you. 2608, requiring supermajority council for approval of county taxes. Commissioner Jay.
We can pass on that.
2610, revised budget transparency and process. Commissioner Stillman.
Think significant pass.
Pass. Okay. 2612, prioritize public safety. Commissioner Stillman.
Pass.
Did you say pass?
Yes, sir.
Okay. Commissioner Stillman, can you speak to the status of that amendment with respect to prospect of merging with 2626 rather?
I'll touch base with Ann to formalize that this week, and we'll have an answer for you next week, if that's okay.
Okay, thank you. 2613, legislative branch employees. Commissioner Stillman.
Close to submitting the form.
2614, performance audits. Commissioner Stillman.
Same.
2615, ethics. Commissioner Gasquet.
We'll need to resubmit the form, and we're still waiting back from feedback from financial services.
2620, limitation on consecutive term limits by council members. I'm the chair. The form has not yet been submitted, but it's going to be updated quickly and probably submitted this week on the new form. 2623, revised council powers regarding boards and commissions. Commissioner Adegwami.
Still waiting on feedback from the financial folks, and we'll be resubmitting the form.
Thank you. 2626, Clark County's requirement to support public safety. Commissioner Donnelly.
Yes, the two committees continue to work on melding 2626 and 2612. We sent our detailed form to Katie and we received input back from her. We sent the amendment to Mitchell Kelly, and he is wondering what the deadline would be because he's very, he has a lot to do. So I will be letting him know that May 6th is that deadline. And we have a meeting tomorrow night to consider how we can get everything done by May 6th.
Thank you. 2631, Ethics Review Commission to consist of 5 members instead of current number. Commissioner Hamlick.
I'll be resubmitting the form tomorrow.
Thank you. I believe that is all of the committees. Move on next to comments by support staff. Michelle, do you have anything that you'd like to share with us?
No, I don't have anything today.
Okay. Kathleen? No. Johnny?
Nothing this evening, Chair. Thank you.
Okay, thank you. Katie, we've heard from you already, but do you have anything else you need to share with us?
I do, and I think it's germane to the discussion that's occurred tonight. So again, after reviewing kind of the spectrum of proposals that have come in, I also want to remind this body that the charter is meant to be somewhat flexible, because you have to remember that we only can amend this every 5, potentially 10 next year, because you have a proposed amendment for that, every 10 years. And so to remind this group that the charter review process to change any language is 5 years or 10, or it requires signatures of 20% of the voters in the last gubernatorial, or it requires 4 votes of council by ordinance. And so when case law comes down from appellate or from the Supreme Court, RCWs change every single legislative session. Federal law changes. This document has to be flexible enough that it can still accommodate for those higher legal opinions that come down. And so overly prescribing the language of the charter is not something I would recommend, because there does need to be some flexibility there. And I want to impose that on this group to think about as you are preparing and getting these packets ready, that's something like, look at the language of the rest of the charter, other charter counties as well, to inform those decisions about how prescriptive this can be, because otherwise, and this is the legal part of it, that if it's not flexible enough, then you're opening up the county to be sued, unless it also is of mind, for these other amendment changes to happen. So, just think about that, because there's been such a spectrum that's come through, and I can answer questions about that, but I just wanted to remind this group of what charters are meant to do. And I would also say that some of what I've seen is actually more appropriate for ordinances. That's what the county code is for, which is much more, it is more flexible, but as residents, you all have the power to also influence and bring forward to council or through the departments changes by ordinance as well. And that might be, as you're going through, I've heard comments about eliminating amendments, that could be the more appropriate way these changes are brought forth for our county.
Thank you. If commissioners have questions on that topic, they can reach out to you directly. Or were you asking to entertain those questions now?
It's up to the chair.
Okay. Unless there's a burning question that is time sensitive, I'm going to suggest that commissioners can reach out to you directly. Thank you. Okay, commissioners, we have no old business. We'll move on to new business, resuming our second readings, starting with Amendment Proposal 2637, County Council Investigative Authority, with Commissioner Silliman as the sponsor. Michelle, could you please put the timer up? $15. And Commissioner Silliman, are you ready?
Yes, sir.
Okay, please begin.
All right. This proposed amendment would change Article 2 of the Clark County Charter. It would allow the complaints about county operations to be directed to the county council. It would also make it clear that the county council or the legislative branch may investigate the affairs of the county and the conduct of any department, office, or agency of the county. This proposed amendment directs that complaints about the county operation should be directed to the legislative branch. This is an essential feedback mechanism for policymakers to determine if the administrative branch is carrying out their policies as directed, or if policies have unintended consequences that need to be changed. There is also no provision currently in the charter granting investigative authority to the legislative branch. The charter currently says that the county council may request information from the county manager. For a council to function as an independent legislative and policymaking body, it must be able to investigate county operations. We've already touched on in two previous presentations the separation of powers, so I'll skip over the next couple slides. But again, this has to do with separation of powers between the legislative or policymaking authority and the administrative branch. The control of information available to the county council to make policy decisions is currently in the hands of the administrative branch. I believe this creates a policy-making imbalance. If they are asking for the county or the staff to give feedback on complaints and the staff provides the answers, that's not, in my mind, always accurate information or clear, because they are in control of the information that is presented. In several other county charters, it's clear that the county council has investigative authority. The Snohomish County Charter clearly says the council may, in connection with the legislative process, make investigations into the affairs of the county and the conduct of any county department, agent, office, or agency, and for this purpose may subpoena witnesses, administer oaths, take testimony, and require the production of evidence, and may invoke the aid of any court of competent jurisdiction to carry out such powers, provided that any witness shall have the right to be represented by counsel. I'll note Pierce County has similar language. This proposed amendment reflects that type of language, the council can suggest this is the current proposed amendment. The county council may, in connection with the legislative process, make investigations into the affairs of the county and the conduct of any county department, office, or agency, and for this purpose may subpoena witnesses, administer oaths, etc. The council as a whole or by committee may conduct public hearings on matters of public concern. It also adds on the next slide, investigative authority. It says the county council shall receive and investigate complaints concerning the operations of county government and respond to inquiries from the public concerning the operation of county government. A council member or legislative branch employee may be appointed by the county council to investigate these complaints. It goes on to say the council appointee shall have, subject to relevant laws, appropriate legal authority and unfettered access to information necessary for them to quickly and efficiently investigate and to make recommendations concerning its findings to the county council. In addition to other duties, the appointee shall monitor and regularly report to the county council on the nature and disposition of whistleblower, ethics, human rights, and any other complaints filed pursuant to other county ordinance or procedures. I want to point out that this investigation power is optional. It says they may subpoena witnesses, administer oaths, take testimony, and require the production of evidence. That may sound extreme, but I believe the ability to compel testimony actually produces the opposite effect because it's not required and it will produce the easier production of information. But direct access to information and the feedback of public complaints allows the county council to serve the public that elected them and produce balanced county policy for the administrative branch to implement. So what is the problem I'm trying to solve? The charter requires separation of the legislative and executive branches. Checks and balances cannot really occur if there's no ability for the legislative branch to independently investigate the administrative branch. This is also why they should receive the complaints about the executive branch. This amendment provides clarity and the ability of the county council to investigate the administrative branch. It's an important evaluation tool for the implementation of policy, which is the council's responsibility, and this produces accountability in government. Whatcom County proposed a similar charter amendment to this in 2025. But it failed, and I think part of that was because it created an independent ombuds office, and I believe that required additional staffing and funding and was separate from the legislative branch. I actually think I touched on it, the role of the council to receive that feedback. I think it's a critical feedback mechanism for them to evaluate how the policy and ordinances that they approve and have passed are implemented so that they know whether they require change or adjustment for the citizens of Clark County. With that, I'd be happy to answer any questions about that.
Thank you, Commissioner Silliman. Start with Commissioner Landsberg, please.
So for the county that passed this, what do they pay their county counselors? Are they more of a full-time? Because I'm looking at how little we pay our counselors and how much time they actually have to spend on county council business. And my second part of this is last week you brought forth an amendment, which I supported, that some of the staff should be delegated to the council. And I don't see how you can do this without that. So I don't know if the amendments should be merged or what.
I see them as related, but it's kind of a separate topic to give them investigative authority rather than just the employees required for them to function. So I think there is an investigative element to this. And just for some perspective on time, when I was a policy analyst working for the county council, they directed all the complaints that came to the board's office to me as a policy analyst, or I might even call it a research analyst if that's important, or research assistant, something, but, and it was only a part-time thing that I dealt with as an employee in the administrative branch. So this isn't like it takes a full-time employee to investigate these. It's a part-time job for a staff person, most likely.
And what's the difference? Because we do have part of the auditing office can actually investigate some of these things. So,
Well, this would be more, I mean, there's a wide variety of complaints that come to the council. It could be about a permit issue that they're frustrated about. Sometimes you just find out what's the other side of the story and you realize the permitting department's trying to work through it and it stays there. Sometimes it's a code enforcement issue. You go down and talk to code enforcement, say, what's the real situation? What's the proposed resolution? What's the statute that we're dealing with? It's just information for the council, and there's nothing that's really done as far as manipulating an answer for it. So there's a wide variety of things, but it's often resolved with just a little bit of information and the ability to go ask staff directly what's going on.
Thank you. We'll go to Commissioner Chrisley, and commissioners will make one quick comment. We have limited time. We have 15 of us. I would ask you to limit your comments to one question. If you have a follow-up question, then you could raise your hand a second time. Commissioner Chrisley.
Thank you, Mr. Chair. Thank you, Commissioner Stillman. What does unfettered access mean in regard to the access to information? And what limitations exist to protect against overreach and conflict?
I'm not sure what overreach and conflict you would be thinking there would be. Right now,
I can clarify if you'd like. I mean,
my concern right now is the charter says any request for information from the council go through the county manager and they can request the information. There is no authority in that statement for them to compel a response from the county manager or any individuals in any other department. So this would give them authority to ask the county manager or any other employee to produce information. I see it as becoming very friendly. They have the right to access the information. Just like a lot of the public has the ability to ask for information, public documents. You actually have a deadline in state law that says, hey, the county has to respond within 5 days or tell you when they're going to respond. This just says, yes, the county has the right to the information and they have the right to request the information from staff to understand what's going on.
Thank you.
Does that answer your question, sir?
Commissioner Garber, please.
So you talked about investigation. I was just wondering, can an individual counselor initiate this independent of other counselors? Or would this be voted on as a group and it would be like the council would do this investigative?
So the way I wrote it currently is the council may appoint a counselor or a legislative branch employee to investigate issues. So they could choose to, I wanted them to come up with their own rules specifically, but the way I wrote it was the group can decide how they are going to implement this specifically, whether individual counselors will be allowed to send requests or if they're going to have a separate employee that's responsible for gathering that information and reporting to the council. So
Commissioner Holmgren and then Commissioner LeBrand, please.
I actually related to something that Commissioner Landisberg said. It feels to me like even your presentations on your proposal for the legislative employees, for the independent investigations and the auditing are all very related. And given the fact that we are concerned about overloading the ballot, I wonder if it is possible to take these ideas and combine them as an effort to address the independence and powers of the legislative body. I think I understand the value of having very discrete, clear amendments, but they all are, I mean, giving your presentation, you're relying on the same kind of language in each. They do flow together.
perhaps if the body here approves of this concept, maybe you could also direct me with the vote and say, would you like to see me combine them in one, if that makes sense? I can pursue that language and bring it back and say, maybe does the body want to approve me combining the three topics into one? If you'd like to.
Commissioner LeBrand.
So we've already got an ethics committee stood up under the charter. And so I'm not totally clear on the value of doubling up on that front I'm not totally clear because the council has the ability to hire and fire the county manager. If they're not getting the answers that they want, why they can't do so. So that's the question more broadly, much more specifically. Suppose a complaint is made and the ethics committee investigates as it's charged with doing, and then the council doesn't like the result. Do they then reinvestigate the complaint separately from the ethics review, the ethics committee?
That's not the kind of function I envision when I reference the whistleblower or ethics complaints. I think the county council should be informed about what complaints have been made through those processes, not that they would be overruling those existing processes. This is more, their direct constituents are the people, and the people ultimately, I believe, have the right to complain through their representatives and say, what's going on here, and for the representatives to be able to find out what the answers to those complaints are. That's really the gist of it. So we even do that at the state level. If we have a problem with a permitting problem with the forestry department, we call up our representatives and say, why is this so hard? Because they're the ones that produce the legislation. So it's a feedback mechanism for the people to complain to their representatives to say, is this the way it's supposed to work, or do you need to produce legislation to change that?
I guess what I'm not getting is what the difference is between what you're proposing and the mechanisms for that, because I think that's important.
Well, because a lot of these, we're not talking about ethics complaints against county employees. We're just talking about process complaints, or an employee didn't treat me nice, but it's more about code enforcement. Those are interactions with the county that people can complain about. You just go down and find out what's the other side of the story, and is it being handled right? What about permitting? There's a lot of frustration with that. The timelines, the requirements, different things. All those are things that our legislators enacted into code that our people have to abide by. So
and they can't currently do that. And they can't currently do that.
Can't currently do what?
Folks can't currently ask their counselors.
Well, they can complain to their counselors, but the counselors don't have any investigation authority to go say, they can't go firsthand, collect information and determine what the truth of the situation is.
Okay. Thank you, Commissioner Snelling. Commissioner Brenton, do you have a quick comment?
Very quickly, I'd just like to say that I think this is a good amendment. It's in line with other amendments from Commissioner Silliman that will increase accountability, transparency, and empower the people's branch of government to serve the people. So I'm very much in support.
Okay, thank you. We'll move to a vote. An affirmative vote would move this amendment to study committee. Michelle, would you please call the roll?
Yes, I will.
Commissioner Ottaguame,
No.
Commissioner Donnelly,
Yes.
Commissioner LeBrandt,
No.
Commissioner Erickson,
Yes.
Commissioner Garber,
Yes.
Commissioner Hamlick,
Aye.
Commissioner Chrisley,
No.
Commissioner Landisberg,
No.
Commissioner Jay,
Aye.
Commissioner Klein,
Aye.
Commissioner Gasquet,
Aye.
Commissioner Holmgren,
Aye.
Commissioner Benton,
Aye.
Commissioner Haas,
Aye.
and Commissioner Silliman.
Yes.
Four nays, it passes.
Okay, so 11 affirmative votes does advance to committee study. We'll next seek to confirm the membership of the committee. Commissioner Silliman will be the chair. Co-sponsors are Commissioner Klein and Commissioner Jay. Commissioner Klein, are you interested in being on the committee?
Yes.
Commissioner Jay,
Yes.
are there any other commissioners interested in volunteering for the committee? Okay, seeing none, then the committee will be comprised of Commissioner Silliman, Klein, and Jay. Thank you. Commissioners, I'd like to suggest we take our final break. Is there a motion to do so?
So move. Haas.
Seconded, Jay.
Okay, are there any opposed? Okay, we will take a quick break. We will come back at 7:16.
We're live.
Commissioners, welcome back. If you could please find your chairs. We'll continue on with our second readings. Next up is Amendment Proposal 2633, Participatory Budgeting Program. With the sponsor is Commissioner Alaguame. Are you ready to begin, Commissioner Alaguame?
Affirmative, Chair. Thank you.
Okay, please begin.
Okay, if we can move on to the next slide. So the Participatory Budgeting Program, 26-33, requires the county to set aside no less than 1% of the general fund discretionary budget for a participatory budgeting program where residents directly propose and vote on community projects. So if we look at, next slide, please, the last few years, and these are the numbers I just pulled off of the county website, so forgive me if they're off by a bit, but I went into the little interactive tool and you select general fund and it shows you what the bucket is. And these are the numbers that I got. So based on those numbers from there, that's about 2 to 2.4 million per year. And so what would that fund? That looks like doing, 10 to 40 sidewalk segments or 88 improvements, doing park improvements, community garden infrastructure, pedestrian safety, trail connections, trailhead improvement. This is about having the ability to propose a project that you can actually see your tax dollars at work, which I think we're at a place in time that people have a very low trust of governments and municipalities in general. So this, I think, helps speak to that. So how does it work? The residents would submit project ideas, staff would review for feasibility, residents would then vote on the eligible projects, council approves via the budget process as usual, and then the county implements that. So council still controls the guardrails, as it were, the eligibility criteria, proposal and voting process. All of that is set by ordinance. The council retains the final appropriation authority. No project is funded without council approval. Why does it matter? Why? It gives residents a direct, tangible stake in government. It reaches people that traditional processes don't. I really want to highlight that. Commissions, boards, council meetings, most of the residents of the county will never go to a council meeting or a board or a commission meeting. But if they have the ability to engage in a process like participatory budgeting and see the impact in their community, it helps build that trust and pull people in and have more involved citizens overall. In the first reading, we had some questions like what exact number is 1%? We addressed that in a previous slide, so we can move past this one as well. We heard, don't boards and commissions already serve this role? They serve an important role, but it's a different one. Participatory budgeting involves all residents. Hopefully, many, many, many of the residents engage with it. They open a proposal, they vote, there's no appointment needed. It's all open to the public to engage with. Boards and commissions are smaller bodies. They tend to have people who are already paying attention, be involved, or who have a specific passion. This process opens it up much wider. It's meant to be complementary, it's not redundant. So boards and commissions might bring the advisory input on policy, but participatory budgeting brings in broad community input. They're not meant to replace one or the other. So would the county need to hire additional staff? The intent is that this is as cost neutral as possible. There are already community engagement staff, neighborhood program coordinators who manage public participation processes. So this would hopefully fold into that area. But again, leaving this quite broad as implementation is not the job of the proposal. That should be done through the county and council processes to get us to the best version of implementation possible. How would participants be selected? They're not selected. Ideas are selected, right? People propose things they want to see in their neighborhood. Those get vetted, voted on by fellow residents, and move forward from there. So a lot of the implementation, again, isn't really a charter thing. We're saying we establish the mandate, we set the floor, and we preserve the council authority. There is a link in here, which is in your materials. You can view it online for those who want to learn more about participatory budgeting in general. This doesn't, and to be clear, this doesn't transfer budget authority from the council. It doesn't let residents just vote on anything they want. These projects still have to be vetted. It doesn't create fiscal risk, or shouldn't at least, still pending review. And it does not replace boards or commissions or any other form of public participation. So again, not a specific process being prescribed, a lot of flexibility there when we talk about implementation. So if we can go to the next slide, please. Some concerns people might come up with, this is a gimmick, the amounts are too small to matter. I think that's not true. 2 to 2.4 million can really move forward a swath of projects in community, depending on the projects. It's not just meant for the areas with the most organized residents. We would hope to see in the implementation phase a lot of participation measures, which would bring in a broad swath of the community. So looking at making sure the projects are allocated around the entire county, like unincorporated Clark County, North County, different parts of the county should all get a similar allocation. So we want to be different than just having that live at a level where only certain pockets get that investment. What if voters pick bad projects? They can't. Projects still have to be reviewed and vetted for feasibility, legal, safety requirements. So all in all, there is some precedent to this. There was a participatory budgeting pilot in Seattle. There was one in King County that's put some elements in. I read about one in Nashville that happened. New York City has had a program, Cambridge, Massachusetts. I think moving on, this deserves to advance because this is something that really puts visible trust into the community through the vehicle of projects that they get to propose and bring to fruition. So that's all I have really. And there's a summary slide as well, but just respectfully ask the commission to vote to advance. Thank you.
Thank you, Commissioner Lagome. Are there any questions from the members of the body? Commissioner Chrisley, please.
Thanks, Commissioner. Thanks, Commissioner Aguame. I just got a question regarding what happens in a budget year when even 1% is too much to a lot. Now we've structured budgetary money into the charter. It's the equate of putting policy into the charter where policy doesn't belong.
Thank you. That's an excellent question. I do think the number itself can change through this process. There might be a need to not be a number whatsoever, but the mechanism for participatory budgeting is the important piece that I would love to see put into the charter. Thank you.
Commissioner Hamlick, you have your hand up.
I do. So I like the idea, Patrick. I think it's a good idea. My question is, have you looked into what the county has kind of already set something like this up with the neighborhood associations on some traffic? They've done the same thing where the council has given a set amount of money and the neighborhood associations can come in, give their advice. So is this already being done?
From what I could find, and thank you for the question, there wasn't the same framework as what we're aiming at. And if there are things like that that are happening currently, I celebrate that and think that's good. And I think we should push for more of that, which is the intent of this proposal.
Thank you. Commissioner Jay, please.
Thank you, Chair. Thank you, Commissioner Aguame. I do appreciate this idea. I think it is a very novel idea, though I'm not entirely convinced it is the best model for a county government as opposed to, say, a city government, as exemplified by most places that have adopted this have been at cities. But I know your presentation intentionally gave some little information on how to actually vote or implement this to give leeway to the council. But there's two main concerns I have with the two approaches, being that if the intent is to have these voted on the general election ballot, then I'm not sure it'll have the same impact on reaching the communities you listed, as there's no evidence that participatory budgeting does actually increase for voter turnout. Most of the time, they seem to use non-voting direct methods, community forums and other ways. But with With that in mind, though, if it is going to go on the ballot as the way, we'll have, it'll complicate the ballot and cost more money to put these things on that isn't specified. But if the intent is to create a separate voting system, then will be a cost of administrating that separate voting system that could exceed the 1% listed. But there would also be a security risk. Like, would we allow for people who are non-resident or resident immigrants to vote, or felons or minors or other people that normally don't vote to have a say on 1% of the budget? That is an initial concern. But I also want to call it that capital budgeting in the county can sometimes take like a decade, as exemplified by the fact that we're still waiting on a pickleball court in Pacific Park. And we're always like one tree away from falling on a bathroom at a park before something else gets delayed. And I'm worried that this might complicate things on that front. But
Was that a comment or?
there's a couple, I mean, the two methods of voting, I think, are a pretty big concern. And I'm not sure if the model fits counties, but if you want to respond, or if not, then.
Thank you. Yeah, I think there are elements, as I pointed out in my presentation, that have been adopted by King County was the one that I could find that was in Washington. And so I do believe that there is a method for implementation. And that's why I'm more inclined to take into account something like Commissioner Chrisley's earlier comment about, is setting a hard threshold something we should do? Perhaps not. But looking at how the mechanism actually gets implemented will be something that should this move forward, will need to be of further discussion. I do hear your concerns about how we would even administer a separate method of participation that isn't just going through the regular voting system. So thank you.
Commissioner Sullivan, please.
Just wanted to clarify, you have a statement that says no Washington County has charter level participatory budgeting yet, but so King County and Seattle, did they pass this or implement it through ordinances that they passed and not charter amendments?
Thank you. Great question. So what I was looking at there was that King County had implemented portions of a program. I think it was a pilot, but it was not in their charter. That's correct.
Okay.
Commissioners, are there any other questions? Commissioner Hamlick, is your hand still up with a new question?
No, sorry about that.
Okay. Okay, seeing no other questions, Commissioner Alagome, are there any other comments you want to make before we go to a vote?
No, Chair. No other comments.
Okay, thank you. Right, Commissioners, we'll take this to a vote. An affirmative vote would move this amendment proposal to a study committee. Michelle, would you please call roll?
Commissioner Ottaguame.
Aye.
Commissioner Donnelly.
No.
Commissioner LeBrandt.
Aye.
Commissioner Erickson.
No.
Commissioner Garber.
Aye.
Commissioner Hamlick.
Hey,
Commissioner Chrisley.
Yes.
Commissioner Landisberg.
No.
Commissioner Jay.
No.
Commissioner Klein.
No.
Commissioner Gasquet.
Aye.
Commissioner Holmgren.
Aye.
Commissioner Benton.
No.
Commissioner Haas.
No.
Commissioner Silliman.
No.
Please hold. Seven aye, 8 nay. Motion does not pass.
Okay, the amendment does not advance to study committee. We'll next move to a second reading of Amendment Proposal 2640, amending the initiative, mini initiative, and referendum process. Commissioner Garber is the sponsor. Michelle, if you could please reset the clock.
Yes, I sure will.
And Commissioner Garber, are you ready to begin once the documents are up? So Michelle, we need 2640.
Oh, did I have another wrong? Oh,
Okay.
sorry.
Commissioner Alagome earlier mentioned he would be deferring that one.
Perfect.
Okay. All right. If you could, you reset the clock, and Commissioner Garber, please begin.
Thank you. Okay, so this is for 2640, amending the initiative, mini initiative, and referenda process. Next slide. The people of Clark County reserve the power to make certain proposals at their option and to approve or reject them at the polls, independent of council. The Home Rule Charter grants the citizens of Clark County the right to initiative and referendum, and no petition has advanced to the ballot since Clark County became home rule in 2014 due to the high signature threshold required. Next slide. A major benefit of the initiative and referendum process is that it gives ordinary citizens a direct voice in lawmaking. With the initiative process, people or groups can propose new laws, bringing important topics to public attention that the traditional legislative branch might ignore. Referendums, likewise, let voters decide whether new laws should take effect, acting as a check on elected officials. This ensures that significant policies align with the wishes of the public, reinforcing the core democratic principle that true authority rests with the people. Next slide, please. Initiatives often spark new ideas and policies by allowing proposals that the legislative branch may find too risky or controversial to be put directly to voters. These measures can result in substantial changes ranging from environmental protections to safety issues and ethics reforms, encouraging legislative creativity that matches society's changing needs. Referendums keep county council accountable by requiring public approval for contested or unpopular laws, making sure elected leaders consistently consider the opinion of their constituents. Next slide. Beyond influencing legislation, initiatives and referendums help create a more informed and involved electorate. They drive public discussion on important issues, educate voters, and frequently boost voter participation in elections. Ultimately, these processes make democracy more interactive by inviting citizens to actively shape the laws that affect them. Next slide. So what this proposal would do, it would amend Article 7, the initiative and referendum section. It would lower the requirement for signatures for an initiative or referendum from 10% to 8%. It would also allow the transfer of signatures from an unsuccessful initiative petition to become a mini initiative if the required 3% of valid signatures have been obtained. And signatures required for petitions that only affect the unincorporated Clark County would be calculated using the same method as petitions for the entire county, which is based on the last gubernatorial election. And then this would also allow the county auditor to choose to use random statistical sampling to verify initiative and referendum petition signatures in compliance with WAC 434-379-010 by sampling no less than 10% of signatures submitted. No petition may be rejected solely on the basis of statistical sampling. So I provided some comparison of the other home rule counties, and you can kind of see we're kind of right in the middle here. There are some that have less percentage required and some that have more. You can see the Whatcom County, that is exactly what I am proposing. You can see that most counties have the ability to do mini initiative, but very few have the ability to take an initiative that was unsuccessful of getting enough signatures to become a mini initiative. But what I find most interesting is the number of initiatives or referendum that have passed. And what it kind of tells me is that an initiative that has wide support will get the signatures, and initiatives that don't have wide support, no matter how low the number is, they're not going to probably get the required amount. Next slide, please. So I put the charter language in here, and if we could just go ahead and skip to the couple pages in where the red type is, Michelle, we can talk about the changes on it. It's on page 10. So you can see I've changed section 3A to go from 10% to 8%. Section B also, and I've removed the language that requires the signatures to be calculated for unincorporated area based on the date the initiative was filed, as opposed to the last gubernatorial election. Next slide.
We're going to skip to 12.
Yes, skip to 12, please. Thank you. And then on this one, we're adding a new section, 7.3, initiative insufficient signatures. If the proponents of an initiative fail to obtain the required number of signatures in the designated time period, but have sufficient signatures to qualify the proposal as a mini initiative, the proposal shall be treated as a mini initiative at the request of the proponents. And then the next slide, we are renumbering the mini initiative and removing the language regarding the unincorporated area based on the date the petition's filed. And the next slide, we are just renumbering the referendum section. And nothing on the next page, but page 16, we are changing the language from 10% to 8% again, removing the unincorporated language. And then the last one is section 7.6, use of statistical sampling for verification of signatures. The auditor's office may use statistical sampling techniques for signatures verification of countywide initiatives and referendum based on WAC 434-379-010 by sampling no less than 10% of signatures submitted. No petition will be rejected on the basis of the statistical method employed. And then renumbering the recall section too. So what problem does this solve? Well, the Home Rule Charter provides citizens with the authority to initiate and approve measures through the process of initiative and referendum. This proposal introduces a minor adjustment designed to enhance the likelihood of success for initiative petitions with wide support and the ability for an initiative with too few of signatures submitted to become a mini initiative. This proposal has been reviewed by the auditor's office, which I'm referring to the elections office, to ensure that no unintended consequences are created with its implementation, and they agree it's a good proposal. And that's it. I'm happy to answer any questions y'all have.
Thank you, Commissioner Garber. We'll next go to questions, starting with Commissioner Alagome, and then we'll go to Commissioner Jay.
Thank you, Chair, and thank you, Commissioner Garber. I believe last time we'd asked how many initiatives or referenda would have made it if we were at that threshold previously. Do you have that information?
I do. So only none. I mean, we've only had one initiative that was ever created, and they did not get enough signatures, so they never even turned it in. And no other one. There's been some mini initiatives that did pass or that did make it to have signatures checked, but no others.
Commissioner Jay, and then we'll go to Commissioner Chrisley.
Thank you, Chair. Thank you, Secretary Garber, for proposing this. I think with this, I think a lot of us ran on trying to make the initiative process more achievable. And so you're doing this commission a great service by allowing for all of us to keep, a lot of us to keep our campaign promises. So I want to thank you for that. But I also want to ask, though, it won't affect my vote on supporting this, but why do you think that the previous amendment and the previous Charter Review Commission's similar proposal to reduce the threshold fail?
I think it had a lot to do with the other piece, the other elements that were included with those. There was one that required the financial impact to be written on the petition or the ballot, saying whether it falls with or financial impact, or whether it was within the scope of a charter amendment. And I think those pieces were kind of argued about, and a lot of people weren't comfortable. I think when you add too much to an initiative, it confuses people and they don't want to vote on it. So I felt this was much simpler, straightforward, with just a little bit of clerical kind of changes.
Commissioner Chrisley, please.
Thank you for that presentation. You know, I'm inclined to support it. I think, you know, as we lower the number, I think that's makes it more feasible. But you said so yourself that there hasn't been any come close. Even if we moved it to 8%, they still wouldn't have overcome it. So I guess I'm just trying to figure out what problem are we actually solving if it seems like we're just adding an amendment to lower the number. It doesn't seem like it would have helped anyway, is my point.
You're right on that, but it might also make people more inclined to go out and start that initiative petition process. But another thing that would happen is it would allow the an unsuccessful initiative to become a mini initiative. And that would be something that would be really instrumental in helping, because it allows a person to have their idea put and have a public hearing through the council. And that's very important.
Commissioner Klein, and then Commissioner Landesberg.
Thank you for this proposal. I agree with your response to Commissioner Chrisley's question. I think that too high of a threshold is a barrier to the public in putting together an initiative. It's a huge undertaking. And I think that this is a good amendment. I will be supporting it.
Thank you.
Thank you. Commissioner Landisberg, please.
What is the difference between a mini initiative and a regular initiative?
Okay, so a mini initiative, there's no time frame on there. They don't have, 120 days to gather signatures. All they have to do is gather 3% of the number of votes cast in the last governor's race. And that would allow their initiative to be talked about at a public hearing. It would require the county council to either approve it, reject it, or modify it. And the other one is through gathering the right amount of signatures and then putting it on the ballot for a vote of the people.
Commissioner Holmgren and then Commissioner Silliman.
I'm noticing here that Snohomish County and a couple of them have lower thresholds for referenda than initiatives. And I wonder if you considered that and rejected it for any particular reason.
I did see that. I was not inclined to lower that. I feel that referendums are, they're put out there by our council. I think there should be a healthy number to kind of reject that. And so I left that alone.
Commissioner Silliman, please.
Just maybe a technical question, but your presentation is very technical. So there is a different requirement for countywide versus just unincorporated areas?
There is. So
But I'm sorry, here's my question. So on 7.6, you're on your statistic sampling, your statement says for signature verification of countywide initiatives. Does that need to also say for or unincorporated area initiatives to apply to that? Or do you think this term covers that?
No, I just wanted it for a full countywide one. So the state, when they do their random sampling, it's based on 3% of signatures. I've made this one 10% because the amount of signatures they would sample would be so low that I don't think it would be a good read. And that's why I also think that we should go based on only countywide petitions, because an unincorporated one, they might have, they would still have quite a few signatures to review, but I think that it would just be more effective for the random sampling because it would lower it from the 28,000 signatures they're going to look at. And I had that number written here earlier. I don't have it in front of me, but it would still, it would lower it substantially, but it would give a high enough threshold of ones that they're sampling to allow for, that random.
So that statistical sampling would only apply to countywide ones, but not the ones that are in the unincorporated only
Yes.
areas. Okay, thank you.
I'll ask a question of my own. Can you talk a little bit about the logic behind including the statistical sampling with the vote thresholds? Are those appropriate to be in the same ballot? Are they two different topics, or can you explain why you think they are appropriate to be in the same amendment?
Sure. Well, I mean, this is a clerical process for when they're reviewing signatures. And this is the section on initiative and referendum. And that would be when they are looking at signatures. So this would be the process for it. And I felt it was appropriate to put it in there.
Thank you. Commissioners, are there any other questions? Okay. Thank you. We'll move to a vote. The affirmative vote would move this amendment proposal to a study committee. Michelle, would you please call the roll?
Commissioner Ottaguame.
Aye.
Commissioner Donnelly.
Aye.
Commissioner LeBranc.
Aye.
Commissioner Erickson.
Aye.
Commissioner Garber.
Aye.
Commissioner Hamlick.
Aye.
Commissioner Chrisley.
Yes.
Commissioner Landisberg.
No.
Commissioner Jay.
Aye.
Commissioner Klein.
Aye.
Commissioner Gasquet.
Aye.
Commissioner Holmgren.
Aye.
Commissioner Benton.
Aye.
Commissioner Haas.
Aye.
And Commissioner Silliman.
Aye.
14-1.
Thank you. It does advance to study committee. Next seat to confirm the membership of the committee, Commissioner Garber will be the chair. We'll next go to the co-sponsors. Commissioner Klein, are you interested in serving on the committee?
Yes.
Commissioner Gasquet.
I don't think I have the time.
Okay. Commissioner LeBrant
Yes.
and Commissioner Hamlick.
No, thank you.
No. Okay. Commissioners, is there any other interest in serving on the committee? Okay, thank you. Commissioners, I don't believe we have enough time to appropriately allow for another second reading to occur in this meeting. So we'll next move to go to the order, and our final two second readings will occur in our next meeting. I'll start with one item for good of the order. I would like to bring to the attention of the body a detail within our study committee protocol with respect to committee presentations. We do have in our protocol the opportunity for committees to make interim presentations to the body. So if your committee is deliberating on a topic and you are not quite sure how the body will react to it, and you would like to bring that to the body for an interim discussion and presentation to get feedback on, that opportunity exists. And if you are interested in that, please reach out to the executive committee, and your committee can be scheduled for an interim presentation without a formal vote. Are there any other topics for good of the order? Vice Chair Haas, please.
I just wanted to illustrate, well, two things. One, if you didn't get your financial thing into the PDC, you have 4 hours. It wasn't that difficult to do because most of it copies over. Second, I don't think most of you have seen or get to know or aware of all of the work that Ms. Gardner's been doing behind the scenes. It's huge. It wears me out, just all the stuff that she says, I'll take care of that. I'll get that done. I'll get that done. And she's just quite the machine. So I want to thank her publicly for not making me do all that work and taking on that huge load. Thank you.
You're welcome.
I would second that as well. I get a front row seat to all that work. Thank you, Commissioner Garber.
I do have.
Are there any other? Okay, Commissioner Garber has one.
I just wanted to remind any of the chairs that really feel that their study committee is going to be, it's going to be very complicated and you need to have more time. Please reach out to us to let us know. So when we work on the schedule tomorrow, that we can understand where we can place you on it. So we can make sure that we're not trying to, rush anybody, but we can complete and fall within this schedule.
Are there any other items for good of the order? Okay, thank you, commissioners, for your attendance today. Thank you for your time. Thank you for your service and for your comments. Is there a motion to adjourn? Second? Is there a second?
Haas.
Okay, any opposed? All right, we are adjourned. Thank you, commissioners.